I'd like to provide a little bit more information about contract law. At first glance, contract law may seem to be difficult and complex, and certainly there are complex details about some of the aspects of contract law, but the basics of contract law are pretty straightforward. There are four elements that are necessary for there to be a contract: agreement, consideration, capacity, and legality. Each of these elements have details to them, but most of the details are really pretty straightforward. For there to be an agreement, there has to be an offer and an acceptance of that agreement. The offer has to be sincere, no joke, nothing forced, intentional, and the acceptance must also be sincere. There's some common sense aspects to offers and acceptances. Offers and acceptances must be effectively communicated. The person making the offer, the offeror, must communicate the offer in some way to the person to whom the offer is being made, the offeree, and the offeree must accept the offer in a manner that the offeror knows that the offer has been accepted. Only the person to whom the offer is intended to be made can accept the offer. Once made, an offer doesn't remain available forever. If the offer says that it has to be accepted by a specific date, when that specific date comes and the time to accept the offer expires, then the offer can no longer be accepted. If there's no time for the acceptance of the offer to be made specified in the offer, then the offer remains available to be accepted for a reasonable time. And what's reasonable depends on what the subject of the offer is. The offeree, the person to whom the offer is made, has three choices. They can do nothing, in which case the offer will eventually expire without being accepted and there won't be an agreement. The offeree can accept the offer and communicate that acceptance in a reasonable way, at which point there is an agreement. Or the offeror, the offeree, the person to whom the offer is made, can expressly reject the offer, which means there will be no agreement. And once an offer is rejected specifically, it can't be accepted later if the offeree changes their mind. The second element of contract is consideration, which deals with what each party to the contract gets out of the contract and or what they give up under the contract. Essentially, each party to the contract must receive a benefit that they're not already entitled to receive, or to give up something that they're not already required to give up. Consideration for a contract is often expressed in terms of money or things, but consideration does not necessarily have to be something that's tangible. Consideration can be a benefit, such as an invitation to an event. Consideration can even be a promise of future action. In a bilateral contract, the parties promise each other that they will each do something specific at a future time. In a bilateral contract, that exchange of promises is the consideration for the bilateral contract. Consideration does have to be something new, something that a party does not already have an obligation to do. If I promise you that I will perform a legal duty that I already have, I have not given any consideration for that agreement and a contract. And consideration must be something that hasn't already been done. If I tell you that I washed your car last week, that action, I've already done it, is not consideration for something you promise me now to do next week. That's not new consideration on my part. And consideration has to be real and it has to be definite. If I tell you that I'll pay you $500 if I like the way you paint my house, that condition that I have to like the way you paint my house before I'm obligated to pay you is not consideration for a contract because I haven't offered to do anything specific unconditionally. Capacity, the third element of a contract, simply means that the parties to the contract have to have the legal and mental ability to understand that they're entering into a contract and that they are accepting responsibilities under that contract. Capacity arises in three circumstances. A party to a contract must be an adult, that's 18 years old under most state laws. A person who is so intoxicated that they can't understand that they're entering into a contract or what their obligations under that contract will be can't make a contract. And a person who's been legally declared to be mentally incompetent or who is actually mentally incompetent at the time that a contract is supposedly made doesn't have the mental capacity to understand that they're entering into a contract or what their responsibilities under that contract will be. Legality, the last element of a contract, simply means that what the contract is about has to be legal. Now, in a contract case, you're often asked to evaluate the contract and the impact of the contract. In a situation like that, the first thing that you do is consider whether or not there is actually a contract. And if all of the elements of a contract are present, then there is a contract. The second consideration in a circumstance like that is, has the contract been breached? Very simply, if something that the contract requires has not been done, then there has been a breach of contract. Now, there are some phases, if you will, of contract completion. If almost everything under the contract has been completed and what remains to be done is minor in nature and a relatively small amount of money can be paid by the breaching party to the non-breaching party, then that's considered substantial performance, and a court won't determine that the contract has been breached, but will award the non-breaching party to the contract a small amount of money, a relatively small amount of money, to be paid by the party that breached the contract or that didn't complete performance of the contract. If the contract has been breached, then the third question is there some excuse for non-performance of the contract or some defense to non-performance of the contract? There are a number of excuses or defenses that might apply. Often the defense of impossibility of performance or commercial impracticability provides an excuse for non-performance of the contract. But for either of those defenses to apply, the event, the thing that happened that caused the impossibility to complete the contract or increase the cost of completing the contract out of all reason, that event has to be something that the parties to the contract could not have reasonably anticipated when the contract was made. The idea is that if there's something out there that the parties to the contract can say, well, this thing might happen and interfere with the completion of the contract, then that thing, that potential event, should be addressed in the contract. And if it's not, then if it could have been anticipated, but it wasn't addressed in the contract, then essentially the courts consider that the parties have taken the chance that that event won't happen, and they've taken a chance and not addressed that event, and if the event happens, then they have to suffer the consequences. If the contract has been breached, and if there's no excuse or defense to the breach of contract, then the last question is, what damages are the non-breaching party entitled to recover from the breaching party because the contract has been breached? And there are essentially three categories of damages that may be available for a breach of contract. The first is compensatory damages, which is an amount of money that will put the non-breaching party in the position they would have been in had the contract not been breached. The second category of damages for breach of contract that may be awarded are consequential damages. These are damages that arise because the contract was not performed, but are not specifically contemplated in the contract. And the third category of damages that might be awarded are punitive damages. You'll have to excuse my cat. Punitive damages are intended to punish the breaching party. Punitive damages are not common in breach of contract cases because typically there's really no need to punish the person who breached the contract.